Does it violate the vehicle and traffic law sufficient to justify a traffic stop if a driver drives over the white fog line 3 times within a tenth of a mile? To find out, you have to read People versus Rufus, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Rufus. The citation for this case is 2024 New York Slip Opinion 06384, published by the New York Court of Appeals on December 19th of 2024. The issue in this case is whether the police are permitted to pull a car over for having gone over the fog line, the solid fog line that separates the lane of traffic and the shoulder 3 times within a tenth of a mile. To understand and appreciate the context of this case, the background that's helpful to know is that case law has established that, in particular, a case called People versus Robinson from 2001 from the New York Court of Appeals, that you're not allowed as a police officer or law enforcement agent to pull a car over for anything less than probable cause to believe that either a crime has been committed or a vehicle and traffic law has been violated. And if you do that, if a police officer or a detective, a law enforcement agent pulls a car over on less than probable cause, less than reasonable cause to believe that a crime has been committed or a vehicle and traffic law has been violated, then the stop is unconstitutional, and all the observations that are made afterwards are what's called fruit of the poisonous tree. They're all tainted by that initial illegal, unconstitutional stop. And as a result, everything else that happened afterwards is subject to suppression, unless there's an exception that would apply. So that's the exclusionary rule in practice with respect to a car stop. And the other thing you have to know is that the vehicle and traffic law of the state of New York dictates the rules of the road that all drivers must comply with. And in particular, VTL 1128A describes the rules of the road for multi-lane highways. And that section provides that whenever a roadway has been divided into 2 or more clearly marked lanes for traffic, a vehicle must be driven as nearly as practicable entirely within a single lane and shall not be moved from such lane until the driver has first ascertained that such movement can be made with safety. So you have to stay in your lane unless you can leave your lane with safety. And the driver has to ascertain that and assure that before the driver can change lanes. All right, what are the facts in this case? The facts are that allegedly on the particular Sunday, Sunday at 2 a.m, when this case took place, the defendant was driving in the right-hand lane of a 3-lane interstate highway. So he's on the rightmost lane next to the shoulder at 2 a.m. on a Sunday. 2 state troopers are driving behind the defendant in a patrol car. The troopers testified later at a hearing that they observed the right tires of the defendant's vehicle cross the solid white fog line, that line that separates the rightmost lane from the shoulder, 3 times within a tenth of a mile. 3 times within a tenth of a mile. The defendant was driving within the speed limit. That's not a problem. The troopers then pulled the defendant over for going over the white fog line 3 times. They then made a series of observations that are adverse to the defendant with respect to his condition and his intoxication, including the following. In response to a request for license and registration, the defendant produced a license, but handed over a plastic sheet that held an air freshener instead of his registration. Inadvertently, the defendant had an odor of alcohol in his breath. The defendant had slurred speech and illogical speech. The defendant had bloodshot, watery eyes and droopy eyelids. He grabbed the car for balance when he exited the vehicle. He took 4 sobriety tests. He volunteered that he had been drinking. He refuses to submit to a chemical breath test at the precinct. He was arrested and prosecuted for driving while intoxicated under VTL 1192-3. And he then moved to suppress all those observations that were adverse to him on the basis that the police had no right to pull him over in the first place because he had not violated any laws, any vehicle and traffic laws or any other laws that would allow them to pull him over. And he argued that all those observations are suppressible because the stop was illegal and unconstitutional. So he has a suppression hearing. The judge conducted the hearing and found that the defendant had violated VTL 1128A because he did not maintain his lane of traffic safely 3 times within a tenth of a mile. The defendant then had a bench trial. He was found guilty of DWI, and he then appealed. He appealed to the appellate division, and they affirmed the suppression judge's decision. They said this was a violation of VT 1128. So then he appeals to the Court of Appeals, and they reaffirm the rule from that People versus Robinson. They say, yes, the rule is still valid. If the stop is not preceded by a violation or probable cause to believe the defendant had violated a law or a vehicle and traffic law, then it's suppressible. Then all the observations made thereafter are suppressible as fruit of the poisonous tree. But then they make the holding that's important in this case for people practicing in this area. They say, and this is the language from the case, when a driver swerves over the fog line repeatedly in quick succession, they have failed to drive as nearly as practicable entirely within a single lane in violation of VTL 1128A. So as a matter of law here, because the suppression judge credited the testimony of the troopers that he did this 3 times within a tenth of a mile, as a matter of law, that constitutes a violation of VTL 1128A, sufficient that the police had a right to pull the defendant over. It was not a constitutional violation. All the observations maintain and the conviction maintains. So on those facts, there was probable cause for the stop. The conviction is affirmed. And that's the case of People versus Rufus. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.